Welcome back to SCOTUS Oral Arguments and Opinions. Yesterday, we discussed RICO versus United States. This case involved the disappearing defendant dilemma and whether a fugitive can run out the clock on their supervised release. Check out yesterday's episode to hear more about this case.
Today, we walk through a forum fight, Hain Celestial Group, Incorporated versus Palmquist. This case sounds technical, but cuts right to the heart of how our federal court system operates. This case asks a deceptively simple question. When can federal courts keep cases that probably never should have been there in the first place? We're talking about a situation where a Texas family sued two companies over their child's severe heavy metal poisoning from baby food, and the whole thing spiraled into a massive jurisdictional mess.
What makes this fascinating is the tension between two fundamental principles. On one side, you have efficiency. Courts hate wasting years of work and forcing everyone to start over. On the other side, you have the bedrock principle that federal courts can only hear cases they're actually allowed to hear.
And the stakes here affect every lawsuit where parties try to manipulate which court gets to decide their case. So, whether you're a plaintiff trying to keep your case in state court or a defendant trying to get into federal court, this decision will matter to you.
Let me read the exact questions the Supreme Court agreed to decide. First, whether a district court's final judgment as to completely diverse parties must be vacated when an appellate court later determines that it erred by dismissing a non-diverse party at the time of removal. And second, whether a plaintiff may defeat diversity jurisdiction after removal by amending the complaint to add factual allegations that state a colorable claim against a non-diverse party when the complaint at the time of removal did not state such a claim.
Now, those questions sound technical, but they're built on some foundational statutory text. The key provision here comes from 28 U.S.C. Section 1332. Which gives federal courts diversity jurisdiction when parties are from different states and the amount in controversy exceeds $75,000.
Right? And the critical phrase is completely diverse. That means every plaintiff must be from a different state than every defendant. If even one plaintiff and one defendant are from the same state, federal courts lose jurisdiction entirely.
So what that means in plain English is that federal courts can hear state law cases, like this baby food lawsuit, but only if two conditions are met. First, the lawsuit has to be worth more than $75,000, and second, every plaintiff has to be from a different state than every defendant. Next, we have 28 U.S.C., Section 1447C, which says, if at any time before final judgment it appears that the district court lacks subject matter, jurisdiction, the case shall be remanded. That language is pretty unforgiving. It says, anytime and shall be remanded.
So what happens when a federal court makes a mistake and dismisses a party it shouldn't have dismissed? Does the court suddenly gain jurisdiction it didn't have before? Or does that jurisdictional flaw poison everything that comes after? Before getting into the case details, let me quickly explain a couple key terms. As mentioned above, diversity jurisdiction means federal courts can hear state law cases when the parties are from different states. Fraudulent joinder is when a plaintiff sues a local defendant with no real legal basis just to prevent removal to federal court. And removal is the process by which defendants can move a case from state court to federal court if federal jurisdiction exists. And a dispensable party under Rule 21 is someone whose presence isn't necessary for the court to provide complete relief.
Let's tell the story of how we got here, because this case started as a tragedy and turned into a procedural nightmare. The Palmquist family, Sarah, Grant, and their son, EP, are all Texas citizens. EP consumed Hain's Earth's best organic baby food almost exclusively for over 2 years. And this wasn't just any baby food. The Palmquists chose it specifically because they believed it offered the highest quality and safest nutrition. EP's mother is actually a doctor at MD Anderson Cancer Center. These were informed parents who thoroughly researched what they fed their child. But when EP was about 2.5 years old, everything changed. He rapidly regressed and developed severe autism spectrum disorder. Tests revealed dangerously high levels of arsenic, lead, and mercury in his blood, leading to a diagnosis of heavy metal toxicity. In 2021, a congressional staff report revealed that Hain's baby food products contained elevated levels of toxic heavy metals. The Palmquist connected this to their son's condition and filed suit in Texas state court against both Hain, the manufacturer, and Whole Foods, where they bought the products.
Now here's where the jurisdictional drama begins. Hain was a citizen of Delaware and New York at the time, so there was diversity between Hain and the Texas plaintiffs, but Whole Foods was also a Texas citizen, just like the plaintiffs. So the defendants removed the case to federal court, claiming Whole Foods was fraudulently joined, basically arguing that the plaintiffs had no real legal claim against Whole Foods and only sued them to destroy diversity jurisdiction. The district court bought that argument, dismissed Whole Foods with prejudice, and kept the case. Important detail, nobody sought a partial final judgment under Rule 54B, so Whole Foods technically remained in the case, even though it was dismissed.
The case then proceeded to trial against Hain alone. After 2 years of litigation and a 2-week jury trial, the district court granted judgment as a matter of law for Hain, concluding that the plaintiffs didn't prove causation. But the Fifth Circuit reversed everything. The court ruled that Whole Foods was not fraudulently joined, that the plaintiffs actually did state a valid express warranty claim against Whole Foods under Texas law. Since complete diversity never existed, the Fifth Circuit vacated the final judgment and ordered the case remanded to state court.
So after years of federal litigation, a 2-week trial, and mountains of legal fees, everyone's back to square one.
The Supreme Court granted certiorari to resolve this jurisdictional question, and for good reason. Federal courts around the country are split on how to handle these situations, and the stakes affect fundamental questions about federal jurisdiction.
The court will hear oral arguments on November 4th, and this decision will provide crucial guidance for how courts should handle jurisdictional errors in removal cases.
Let's break down how each side approaches this problem. Hain and Whole Foods, the petitioners, make 3 main arguments for preserving the federal court judgment.
Their first argument draws on the Supreme Court's 1996 decision in Caterpillar, Inc. versus Lewis. They argue that when a federal court dismisses a nondiverse party before entering final judgment, that dismissal cures the jurisdictional defect. As Hain puts it in their brief, even if a court sitting in diversity lacked jurisdiction at the outset of a case, that jurisdictional flaw can be cured by dismissal of a non-diverse party prior to entry of final judgment.
They trace this principle back to 19th century cases like Horn versus Lockhart from 1873 and Connolly versus Taylor from 1829, where federal courts cured jurisdictional flaws by dismissing non-essential, non-diverse parties.
Their second argument focuses on efficiency and finality. Drawing again from Caterpillar, they argue that once a diversity case has been tried in federal court with rules of decision supplied by state law, considerations of finality, efficiency, and economy become overwhelming.
Essentially, they're saying that requiring everyone to start over in state court would impose an exorbitant cost on our dual court system, a cost incompatible with the fair and unprotracted administration of justice. Their third argument involves something called the Newman-Green Doctrine and Federal Rule of Civil Procedure 21. Even if the district court was wrong to dismiss Whole Foods, they argue the Fifth Circuit should have exercised its discretionary power to dismiss Whole Foods as a dispensable party to preserve the final judgment. The Palmquist, the respondents, push back hard on all 3 points. Their core argument centers on the distinction between voluntary and involuntary dismissals.
They emphasize that in Caterpillar, the non-diverse defendant was dismissed because of a voluntary settlement. As they put it, all claims involving the non-diverse defendant were settled, and the case became a 2-party lawsuit. But here, respondents opposed the dismissal of Whole Foods and never voluntarily abandoned their claims against this proper and non-diverse defendant. Drawing on the recent Royal Canin decision, they argue there's a substantial difference between a voluntary dismissal and an involuntary dismissal. The former situation means the abandoned claims are gone for good, while in the latter situation, they remain part of the case and could be revived.
Their second major argument invokes the principle that federal courts have limited jurisdiction and plaintiffs are masters of their complaint. They argue that the plaintiff is the master of the complaint and therefore controls much about her suit, including the right to establish or not the basis for a federal court's subject matter jurisdiction.
They contend that allowing petitioners' approach would invite federal courts to enlarge their own jurisdiction by adjudicating cases that belong in state court and would undermine the requirement that courts resolve doubts against removal and in favor of remand.
Their third argument simply denies that any cure occurred. They argue that because Whole Foods was improperly dismissed and remained in the case, evidenced by its participation in the appeal, the case has lacked complete diversity at every minute from the moment of its filing.
Looking ahead to the November 4th oral arguments, I think there are several key dynamics to watch for. First, how do the justices react to the voluntary versus involuntary dismissal distinction? This feels like the kind of nuanced argument that could really divide the court. Do they see a meaningful difference between a settlement dismissal and an erroneous court-ordered dismissal?
I'll be listening for questions about practical implementation. Justice Gorsuch or Justice Thomas might ask, if we adopt the Palmquist's rule, what happens to the thousands of cases where federal courts have made similar mistakes? Do they all get undone?
The efficiency arguments could really split along ideological lines. The conservative justices generally favor finality and judicial economy, but they also tend to be strict about jurisdictional limits. The liberal justices might be more sympathetic to protecting plaintiffs' forum choice.
I'm particularly interested in how the justices handle the Newman-Green argument. That doctrine gives courts discretionary power to dismiss parties to preserve jurisdiction, but it requires considering whether dismissal would prejudice any of the parties. The Palmquist argue their preference for state court is exactly the kind of tactical advantage that makes dismissal inappropriate.
And watch for questions about the second question presented, whether plaintiffs can defeat diversity jurisdiction by amending their complaints after removal. This touches on forum manipulation concerns that several justices have expressed in recent years. Given the court's recent emphasis on strict jurisdictional rules in cases like Atlantic Marine and Bristol-Myers Squibb, I suspect at least some justices will be skeptical of arguments that prioritize efficiency over jurisdictional limits.
This case matters far beyond just the Palmquist family and their tragic situation. The court's decision will affect how federal courts handle jurisdictional errors in thousands of removal cases every year.
If the court sides with Hain and Whole Foods, it could make it much easier for defendants to keep cases in federal court, even when removal was initially improper. That shifts power toward defendants who often prefer federal court for strategic reasons.
But if the court sides with the Palmquists, it reinforces the principle that federal jurisdiction can't be bootstrapped through judicial error. It protects plaintiffs' right to choose their forum and ensures that jurisdictional requirements have real teeth.
This case also sits at the intersection of several broader trends in Supreme Court jurisprudence: the tension between judicial efficiency and strict rule enforcement, questions about forum manipulation, and the balance between federal and state court authority.
We'll definitely be covering the oral arguments on November 4th, so make sure you're subscribed. This feels like a case where the justices' questions might reveal how they're thinking about these competing principles.
Thanks for joining us for this deep dive into Hain Celestial Group versus Palmquist. It's a perfect example of how seemingly technical procedural questions can have enormous practical consequences for how our court system operates.
As always, if you found this helpful, please rate and share the podcast. Thanks for listening to SCOTUS Oral Arguments and Opinions. If you enjoyed the content, please subscribe, rate, and share.
In our next episode, we discuss Ham versus Smith, a case that involves questions about when a person's IQ score can render them intellectually disabled and incompetent to stand trial. Talk to you soon.